I would like to introduce someone who you already know and love, Daniel Mackler.
Good morning. So I get to introduce Jim. I'm excited. Couldn't really be happier to introduce anyone else. I think it was 2 years ago I was feeling the urge to have a real adventure, and I decided, I used to hitchhike when I was like 20 years ago in my early 20s, and I thought, I want to hitchhike somewhere. And I was like, I think I'm going to hitchhike to visit Jim. I was in New York, and Jim lives in Alaska. So I hitchhiked up there, and it took a while, but I ended up on his front doorstep. And it's like, part of it's because I just like Jim and I trust him, but part of it's like the work that he does. And I think his idea about how to change the mental health system is personally, I think it's brilliant, this threefold way of doing it. And public education, creating real alternatives, and strategic litigation. The one that I don't understand that much is the strategic litigation, which I'm glad to hear, why I'm here now. But the part about creating alternatives, a lot of people talk about creating alternatives. A small number of people really create strong alternatives. Jim's created like 3 or 4 in Anchorage, Alaska. I got to work at Soteria last year, and he did it, and it's brilliant. Like this idea of what he's doing to actually create things that people can get out of the system and try real alternatives. He's done it, and when I was there, it was very interesting to see how his threefold system works. I think, and they all feed into each other. Jim is an interesting and controversial figure in Alaska. Some of the very people who he's actually suing, he's doing strategic litigation with, have a lot of respect for him. I talked to them, and they're like, some of them are actually sending people to some of the alternative programs that he's created because they realize how useful they are. And I asked a few people, I was like, there's lawsuits going on. You know, he's suing your organization and a hospital or things like that for the horrible things that are going on. How come you're sending people to a place that he's created? And they would say things like, because it's good, because it's helpful. And it was sort of like that people could see beyond this. And it's like it was real system change happening right in front of me. I saw it. The third thing, I was thinking about what I was going to say. What would I say very briefly about his public education stuff that he's doing? And then I realized, PsychRights. I'd say probably 10 times a week I send people to his PsychRights organization, to his website. And another part of it is I go there myself all the time. It's an absolutely incredible resource. If you've never been to PsychRights.org, it's a humongous website. And there's just an incredibly gigantic amount of stuff, and people find it very useful. And for me, it's like that's a big part of it. So I realized that Jim is actually doing all 3 of the things that he talks about, and that's part of why I really value him. Is he's doing it. So I'm just glad to welcome him, and it's great to be here, and it's always great to see Jim, because living on the other side of the country, I don't get to see him as much as I'd like to.
I'm not quite as tall as Daniel. Can you hear okay? Yeah, okay. Thank you very much for those very kind words, Daniel. And I want to thank NARPA for inviting me, and I really want to thank NARPA and John and Ann for all the help that they've given, and various needs that I have. And I especially want to thank them for adding at the last minute my talk on the Medicaid fraud initiative and our big victory in the 7th Circuit, which is going to be tonight, because it's a big curve to throw that kind of thing at conference organizers right at the last minute, and I really do appreciate that. I come to this group talking about the role of strategic litigation and mental health system change with a little trepidation, because when I'm the only lawyer, things are much clearer. So anyway, I'm happy to have people discuss my thoughts on on the legal stuff. Anyway, let's get right to it. So the Law Project for Psychiatric Rights is a public interest law firm whose mission is to mount a strategic litigation campaign against forced psychiatric drugging and electroshock around the country. Well, and we're really focused on this horrific drugging of children, and especially poor children on Medicaid, and God help those in foster care. So, how many people have read Anatomy of an Epidemic? Okay, about 80%. So those who haven't, you really should. And actually, Robert Whitaker, who wrote Anatomy of an Epidemic, wrote this previous book, Mad in America, which I know a lot of you have read too. And that was actually what caused me to form PsychRights, because while I've been doing work in Alaska, not precisely on this, and while I had a pretty good idea about the drugs, I didn't feel that there was anything that I could add really to the effort until I read Mad in America. And then to me, it was a litigation roadmap, in addition to being a great book, about how to challenge the system, not based solely on the civil rights issue, which of course is hugely important, but also on the idea that it's not really in people's best interests to be drugged against their will. So that's, I highly recommend that. And a lot of this initial stuff that I have here is taken from Mr. Whitaker's work. And that is, and I want to kind of set the stage for where the role of litigation comes in, and then talk about a transformation triangle. You know, where all this stuff fits into this strategic approach. Okay, so there's been a six-fold increase in the rate of people that are categorized as disabled as a result of mental illness since the so-called miracle drug Thorazine in 1954. And there's no question in my mind that the bulk of it is because of psychiatric drugs. And I mean, I think that it's not all of it. Some of it, I think, is the welfare to work requirements that came in, about 20 years ago. And so before, where people could just kind of be on welfare indefinitely, now they had, in order to do that, they've got to get, labeled as being disabled. And so I think that's some part of it, but not really that big a part of it. The drugs clearly cut the recovery rate at least in half. And they're causing a huge amount of physical harm, to the point where people diagnosed with serious mental illness in the public mental health system have lifespans that are 25 years shorter than the average lifespan. And the fact that nobody really cares about that except us, I think says volumes about how little society cares about people once they've been diagnosed with a serious mental illness. Okay, and of course, having all these people on disability, getting transfer payments instead of paying taxes, getting all this assistance, the drugs cost a lot of money, all the mental health industry that goes up around it costs a lot of money, so it's hugely expensive, and of course it causes a huge unnecessary human toll, which is what we're most interested in. Okay, so there was a study a few years by Harrow and Jobe that is considered the best naturalistic long-term study that showed basically that people who quit their drugs had a 45% recovery rate, and people who stayed on their drugs had a 5% recovery rate. And this was recently basically been replicated in a randomized controlled study somewhere in Europe, maybe the Netherlands or Sweden or somewhere. Anyway, so, and I'm going to, if I remember, contrast that a little bit later with what we're seeing out of the open dialogue approach. Okay. So here's a graph of this six-fold increase. In 1955, there were, 213 per 100,000 people that were disabled and categorized as mentally ill. And now it's in 2007, it's 1,315. So that's, over a six-fold increase. So quite dramatic. And I think as each class of drug came in, especially the SSRI antidepressants, which I'll talk about in a bit, that increased the disability rate. Okay, so let's talk about children a little bit. Massive amounts of drugging of children. 1 in 10 boys are on stimulants like Ritalin or Adderall. More than 1% of children under 18 are being given neuroleptics. There's no long-term proven benefit. The short-term benefit is mainly for adults. And I think basically if you're for the adults and the children's lives. And I think if you look at the coercive mental health system, basically all of it is about the comfort and convenience. I don't know about all, but a very large percentage of the forced so-called treatment is really for the comfort and convenience of other people rather than the person who's being forced to do things. Okay, 1 in 40 are on antidepressants. In the Prozac Boys study, 23% developed manic-like symptoms, and 19% more had drug-induced hostility. So this is where we're seeing people converted, given these drugs, and then become manic, and then they get diagnosed with bipolar disorder. And so I'm sure virtually everyone in this room has heard the phrase, oh, we've unmasked your bipolar disorder, right? Right, I mean, it really is absurd, but they say it with a straight face, and rather than just withdraw the drugs, they say, okay, now we know you're bipolar, and then they put you on these worse drugs with all those attendant problems. I mean, there's a psychiatrist at Harvard Medical School, Joseph Glenmull, and he's done some work where someone would become manic after being given one of these antidepressants, and so he'd withdraw it, and they stopped having manic symptoms, and then he'd give it to them again, and they'd have them again, and then he'd withdraw them, and they'd stop. And so that's called a challenge, de-challenge, re-challenge approach. And everybody says, there's this perception that these randomized controlled trials are the, quote, gold standard, are the best way to conduct research. But these challenge, de-challenge, re-challenge studies really are quite good, and the randomized controlled trials are so corrupted now with design and coding, basically fraud, that they're really just tools of the pharmaceutical companies. All right, so as a result of this, the bipolar rate of children went from virtually nothing in 1995 to close to 800,000 in 2003. Okay. Even 6-month-old babies are being given neuroleptics. I mean, there was kind of a competition for a while for psychiatrists to see who could diagnose the youngest child with bipolar disorder. And they're even, I kid you not, they are talking about diagnosing fetuses in the womb with bipolar disorder. That, if they kick a lot, then they've got bipolar disorder. I'm not kidding you. And you tell me what these drugs were developed for adults with psychosis, and you tell me what a psychotic 6-month looks like. We used to have a different name for it, colic. So the mental health disability rate on SSI soared from virtually 0 in 87 to 800,000 in 2011. And so this is just a huge disaster that it's unfolded before our eyes. It's getting worse every year. And I think it's an emergency. Okay. In contrast to that, we know that there are other approaches that work far better for people without the harm. The Hearing Voices Network, I think people know about that, but basically a pretty large percentage of the population hear voices, and it's around 10%. And the people that get diagnosed with schizophrenia are the ones where the voices cause them problems dealing in society. And so there's this group that developed in the UK, but it's finally gotten over here to this country. I suspect a lot of you know about it. How many know about it? Yeah, almost everybody. Okay. And the basic thing, you know, it's kind of the peer support thing, but the basic thing is to learn how to, you know, deal with the voices. And the question they ask is not what's wrong with you, but what happened to you. And there's a growing similar network for people who experience strange or unusual beliefs, which get diagnosed as delusions, the same kind of approach. And there are other psychosocial approaches that have been shown to be very, very effective for very many people. Soteria, open dialogue, peer-directed. So up here are the statistics for the open dialogue approach in the western part of Lapland, I believe. And their approach basically is that the problem isn't in the person that's, you know, that's experienced the symptoms. It's within the whole community, and they think of it as the space between people. And they bring everybody in. They never talk about the person without that person being invited. And what they have found, that 79% of the people coming in with psychosis are asymptomatic at 5 years, after 5 years. Okay, and it just happens that 20% of the people, only 20% of the people are using neuroleptics at the end of 5 years. So it's perhaps not, I mean, it's not 100% overlap between recovery and not being on the psychiatric drugs, but it's a very high percentage of it. And when you contrast that with what Harrow and Job found, where they found 45% people recovered, and it's like, well, I was thinking, why is there that difference? 45% recovery and 80% recovery. And the obvious difference is that in the Harrow study, these were people that had been put on the drugs and had gotten off of them. And so to me, the message is how important it is to really selectively use these drugs and really find out who needs them before. And of course, from my perspective, the who needs them needs to be the person themselves to decide. Now, I should say, I mean, I come across as anti-psychiatric drugs, and I pretty much am, but I also know people who find them very helpful, and I think they should have access to them. I think they should be told the truth about them, including that there are other approaches that work for people without all the harm. But even if they're not interested in that, if they want to take them, I mean, I think that's their choice. And so what PsychRights is all about is trying to help people not be forced to take it. Now, children are a totally different topic. I just don't think neuroleptics should ever be given to the children. I think there's a big question if the stimulants should be given to children at all. So anyway, so Daniel Mackler did this great video on the open dialogue approach. I think a lot of people saw his newest film, Coming Off Psych Drugs, but an earlier movie, Open Dialogue, is also very good, and I highly recommend it to really get a feeling for what they're doing. Okay, the Soteria Project, which was a National Institute of Mental Health study in the 1970s, had very similar results to what they're seeing in the open dialogue approach. And their idea, again, was a selective use. They didn't say never. They didn't use them for the first 6 weeks. The neuroleptics. And by the way, I don't like to call them antipsychotics. I mean, that's a marketing term. They don't really have antipsychotic properties for most. They basically block 70 to 90% of the dopamine in the frontal lobes, the basal ganglia, and the limbic system. And so they're literally a chemical lobotomy. And so some people find that they help with symptoms, but basically they just make people so that they're incapable of bothering the other people in their lives, and B, they kind of make people not be so upset about the symptoms that they're having, be apathetic. But anyway, the Soteria Project also found that they only had 19% regularly maintained drugs during the follow-up period. So that's very similar to the open dialogue results. And what was the National Institute of Mental Health's response to these incredible results in the 1970s? It was, okay, that's fine, study over, go away, Dr. Moser, who did this study. And he went on leave. They told him his job would, he went to Italy, I think, because they abolished hospitals in Italy. And said his job would be there when he came back, but it wasn't. Okay, the same is true for children. That there are other approaches, and I highly recommend a criticalthinkrx.org program on the web. It's a program designed to educate people deciding about whether to give drugs to children and youth, and it was funded out of the settlement of the False Claims Act settlement of the Narantan false, illegal marketing scheme, and so they put some funding into that. And Module 8 is all this evidence, proven psychosocial approaches that work, that have been proven to work with children and youth. But if I would say that I think that really think of how to help children, there are really two things that basically all of them do. One is to help the parents be successful in parenting. There are a lot of pressures on parents, and we just need to give them help and teach them how to really discipline their children. Give them the attention that they need. I mean, that's a really big problem right now. Is children need attention, and our society is set up, so children don't really get the attention that they need from their parents, and we really need to help that. And then we need to help children and youth be successful, right? I mean, that's what it's all about. And so, and deal with their problems and learn how to regulate their emotions. So it's really, I mean, this is really proven stuff, and the drugs really are counterproductive and physically very harmful. Okay, so I'm going to go into more detail in the legal stuff, but I wanted to give this background for what I call the transformation triangle, which is not really a triangle. And if anybody can come up with a better name, I'm happy to use it. And I hate the word transformation. Transformation has kind of gotten co-opted by the system, but anyway, it's alliterative, so I like that. So Daniel described this a little bit before, and I'm going to go into it a little more detail. The idea is that these three spheres, public attitudes or public education, other choices or alternatives, strategic litigation, or honoring people's rights, all reinforce each other in ways that can lead to system change. So, for example, society right now doesn't believe what we believe, that the drugs are very harmful, that they're very counterproductive, and that there are these other approaches that really work. Okay, but if, to the extent that we can change that public attitude, the public is going to support these other choices, including with funding. And when I say the public, I don't mean talking to ourselves. I mean getting the message out. Okay, by the same token, to the extent that we have these alternatives going and demonstrate that they work better and get that word out, then that's going to change public attitudes. So they reinforce each other in those ways. And I think, the people in this room, some of the people in this room are really doing great work in that area. And I'm thinking that we're beginning to see that. The open dialogue approach has gained some traction here. People are trying to open Soteria houses. Peer-run respite centers that allow people to decide whether to take the drugs or not are starting to become more prevalent, I think. So I think these are really important developments. And what we need to do is document the successes and get the word out. And getting the word out is really hard because of the pharmaceutical industry's stranglehold on that. But, in the age of the internet, this is something, that really it's possible to kind of bypass the media, and it's happened a lot in other areas. And in fact, Anupa and I are giving a little workshop after this on the use of social media for that purpose. Okay, going down public attitudes and strategic litigation. So I characterize the legal system, including the judges, and let's really focus on the appointed the lawyers appointed to represent people, except those in the room. We've got at least a couple of great people in the room who really do try and represent their people well. But as a rule, I think the attitude of the public defenders is, if my client wasn't crazy, she'd know this was good for her. And they don't really defend the cases really very well at all. And I think that's a violation of their professional ethics, and I've been kind of toying around with the idea of actually filing something with the Alaska Bar Association about that. The problem I have with that is it's also not entirely their fault, because they are not, they're given so many cases. In Alaska, they may have gone to 3 times a week, but they had hearings Tuesdays and Fridays from 1:30 to 4:30, between 5 and 10 hearings a week. Everybody except the respondent got to go home for dinner, and the public defender usually hadn't met with the person except right before the day. They call no witnesses. And I went to a really terrific seminar by Bill Brooks, I think the last time I was here, on cross-examination, and that's really important. But I think it's really hard to win cases with the other side's witnesses. And so, you need to bring your own witness, and the respondent might testify, but they come in with huge credibility problems. So there's no investigation, there's no bringing in family or friends or something like that. There's nothing about alternatives. And so anyway, I'm very negative about the way the legal system, I'll take questions later, the way the legal system deals with it. I basically consider them sham proceedings. Okay, so strategic litigation, how does that affect? It's a little bit harder to see how that works going up the other way, but to me the best example I've come up with is Brown versus Board of Education. Before that case in 1954, the United States Supreme Court, 75 years earlier, had said separate but equal was constitutional. Segregation was constitutional. And a lot of people thought it was okay. The Supreme Court had said it was okay. A lot of people, of course, didn't think it was okay. But now, I think that that case really played a significant role in the, where we're at now, where virtually no one will admit that they believe segregation is okay. Now, there's probably still a pretty small minority that believes segregation is okay. But basically, the vast majority of people in the United States think segregation is wrong, and I think that, that's an example of litigation being able to affect public attitudes. Okay, now down at the bottom, and I'm going to talk about this in more detail, assuming I have time, which I think I do. One of the core constitutional principles is you can't drug someone or lock them up, drug someone against their will or lock them up, and if there's a less restrictive or less intrusive alternative. Okay, so and what that technically means is that if the state could provide it, that the court cannot order the drugging or the involuntary commitment. It doesn't have to actually exist for that right to not be drugged or locked up. Okay, but it's pretty hard, and so that really forcing that point in litigation can cause a lot of pressure to create these kind of alternatives, because you've got all these people that are causing problems or perceived problems, and so the society wants to do something with them, and if they can't do what they're doing now, then that's going to be pressure to create these other alternatives. At the same time, it's pretty hard to get a judge to say, I'm not going to confine this clearly psychotic person, and dangerous, although dangerousness is this whole other thing, but let's say that the judge feels something needs to be done, and it's pretty hard to get a judge to say, well, I'm not going to do anything because what he's entitled to doesn't exist. So if we have these other alternatives that are available for people to go to, then makes it much more likely that their right to not be drugged, if there's a less intrusive or less restrictive alternative, to be honored. Okay, so that's the basic theory. And I want to just go through some basic legal principles. Probably everybody knows about them, but to focus a little bit more on this litigation aspect. Okay, so the hallmarks of procedural due process are meaningful notice, meaning people have to be told what they're being charged with or what the claims against them are, and a meaningful opportunity to be heard, meaning getting to tell their side of the story by a neutral decision maker. Okay, that's just basic due process. And I've got a case in the Alaska Supreme Court right now that relies on this. Okay, so for substantive due process, if it's a fundamental right, then the state can't infringe on that right. I mean, no rights under the U.S. Constitution are absolute. I think that's a true statement. But if it's a fundamental right, the state can't infringe upon it unless there's a compelling state interest, a really important reason why this person's fundamental right is going to be infringed, and it has to be the least restrictive or least intrusive alternative, which I already talked about. Okay. The United States Supreme Court has clearly held that involuntary commitment, which, let's just be frank about it, is really psychiatric imprisonment, is a deprivation of the fundamental right. Okay. And the Alaska Supreme Court said it was under the Alaska Constitution. I think it probably is in most or all states. And so that's kind of a duh. Locking someone up is a deprivation of a fundamental right. The Supreme Court has called it a massive deprivation of liberty. Okay, my view is that forced drugging is probably a deprivation of a fundamental right under the U.S. Constitution. When I told Susan Stephan that, she said, well, the Supreme Court has never said that. And it was interesting, at Kirk Lowry's workshop yesterday, he kind of assumed it was a fundamental right. And there's a reason why I think that it is. But anyway, it probably also is under many state constitutions. Okay, so the U.S. Supreme Court says that involuntary commitment is allowed when the confinement takes place pursuant to proper procedures and evidentiary standards. Okay, you got to follow due process. You got to have legitimate evidentiary standards, and that there's a finding of dangerousness either to oneself or to others, and that dangerousness is coupled with the proof of some additional factors such as mental illness or mental abnormality. And then, and that's Kansas versus Crane and Cooper versus Oklahoma, they said being unable to take care of themselves can constitute danger to self if that makes a person incapable of surviving safely in freedom. And I really focus on the word surviving, which means they're going to die if it doesn't happen. So I think there's a pretty basic question is why the state should even be allowed to do this in the first place. You know, it's kind of preventive detention if no crime has been committed. But anyway, the Supreme Court has said these are the standards. With respect to forced drugging, there was this case, United States versus Sell, which was a dentist. Sell was a dentist, excuse me, who was accused of Medicaid fraud, and he was found to be incompetent, and they wanted to drug him to make him competent. And so, as a little aside, so, you know, the person, what's his name? I forget, but the person who shot Gabby Giffords in Arizona, Jared Loughner, yeah. So he really resisted being drugged to be made competent to stand trial, and of course the court said, yeah, I'm going to drug him, and it went up to the Ninth Circuit, and they basically said no. You didn't follow Sell, so it went back down, and the court finally did order him to be drugged, and it went back up, and the Ninth Circuit approved it. But to me, the most interesting thing is there was a newspaper account of like a 7-hour hearing where Loughner had just sat quietly during the whole hearing without saying anything, whereas previously he'd been kind of disruptive. And that was the evidence that he was competent to stand trial. You know, and the standard is that to be competent to stand trial is that the person is capable of understanding the charges against them and to assist counsel. So, you know, basically if you're drooling at the table, that means you're competent. And that's, so anyway, the whole idea that you can drug someone to make them competent is pretty shaky. I think maybe, you know, in some cases. But getting back to Sell, what they said is that in order to do this, you have to show that there's an important governmental interest at stake. Okay, so this is one of the reasons why I think it's a fundamental interest, right, is that kind of sounds like that analysis. Okay, and there was actually, I think in that case, they said, you know, maybe because of, you know, how serious the effects of these drugs are, that maybe prosecuting someone for Medicaid fraud isn't sufficient to justify drugging someone. Okay, the drugging also has to significantly further those interests. In other words, it's got to work, and it's unlikely to have side effects that will interfere significantly with achieving that. Okay, and it's got to be necessary to further those interests. Okay, the court must find that any alternative, less intrusive treatments are unlikely to achieve substantially the same results. And it's got to be medically appropriate, in other words, in the person's best medical interest in light of his medical condition, considered on a drug-by-drug basis, which I thought was really important. So when I look at the involuntary commitment standards, and I look at the forced drugging standards on the Constitution, what I think is that no more than 10% of the people who are locked up actually meet the commitment criteria. And one of the reasons for that is that you have to prove that the person is dangerous by clear and convincing evidence. And of course, in a normal civil case, it's just got to be a preponderance of the evidence, which means more likely than not, over 50%. In the criminal context, it's got to be beyond a reasonable doubt. Clear and convincing is in between that, and there are different formulations of what that means in the states. But to me, one of the interesting things was when the Supreme Court decided it has to be by clear and convincing evidence, of course, the respondent said it should be beyond a reasonable doubt. You're locking someone up. It's like criminal. And the Supreme Court said, well, psychiatry is such an inexact science. There's no way they could ever prove that. So we're going to make it clear and convincing. And I would suggest that when you look at the research on predicting dangerousness, or as Professor Brooks would say, assessing danger, the best they can get is 50%. I mean, if they don't, very carefully follow these, instruments and tests and surveys and factors that have been developed, because before that, they just found that it was practically random, that the psychiatrists just totally over-predicted. If they really follow all that very carefully, they can only get up to 50%. Well, that doesn't sound like clear and convincing to me. Okay, so with respect to forced drugging, when you look at all that evidence that I that I went through before, I don't think you can prove it's in someone's best interest by clear and convincing evidence, ever. And I don't think that you can really show that there's no less intrusive alternative, hardly ever. So I think, just on this, that really that forced drugging is unconstitutional. And the reason why it's done so much is, of course, society's beliefs in it, and that in the main, the lawyers are not doing their jobs of discovering this information and presenting it to the court. So I hope the next slide is, ta-da, it is, the forced drugging defense package. So it's really hard to get experts. And so one of the things that I started to do, and actually, I tried to get Robert Whitaker qualified as an expert in one case, and a judge wouldn't do it. And so now what I've done is say he's a fact expert. He's a fact witness on what these studies show. He's not issuing an opinion. He's just giving the facts on these on what the research shows. Grace Jackson has been qualified as an expert in a number of my cases. But what I did in one case is I got them to prepare affidavits, because he wouldn't let them testify. So I said, the hell with this. I'm just going to file it and make the record. Of course, I could have done an offer of proof. But in any event, so we file it I filed it as pre-filed testimony, direct testimony. And then what we've done is we've said, okay, we will make available, and Mind Freedom has certified copies of these affidavits that should be admissible around the country, so that people can actually try and get this testimony into court. Now, of course, the state is entitled to cross-examine, and Mr. Whitaker, within reason, in terms of how many times, he's pretty much willing to do that. And in one of my cases, you know, they insisted that he be cross-examined, and basically with the hope that we couldn't get him. In Alaska, it's so big, you know, and there's so many remote places that we can pretty much always get telephonic testimony allowed, so it's pretty easy. We had someone filed some written testimony from someone in New Zealand, and they insisted on cross-examining that person. Same thing, and we got her on the phone, and they basically didn't do any cross-examination. Okay, so the forced drugging package, and this is on our homepage, PsychRights.org, we have a motion, a kind of generic motion and memorandum for summary judgment to oppose forced drugging. And it's based on cell and all this evidence. And it includes also a motion for stay pending appeal. Because my view is you tend not to win these at the lower court, and that the appellate courts tend to respect these legal principles much better than the trial courts. I mean, one of my things in Alaska is you have the right to a jury trial for the 30-day one you don't, but then they go to 90 and you have the right to a jury trial. And the judge is always going to rule against the respondent. So I think as an ethical matter for a lawyer, you have to ask for a jury trial because at least you have a chance. And actually, I've done a sum total of one jury trial all the way through to the end. But in that case, it was Mr. Bigley who had been involuntarily committed for 70 times at that point, and we won. Because the jury actually paid attention to the law, as you know, in the jury instructions, and the judges, I think, basically don't. I mean, they don't want to be held responsible if they let someone go and something happens. I think that's a lot of what's happening. But in any event, we got a stay from the Alaska Supreme Court on that case, and since they couldn't drug him, they just let him go after they had gotten him committed. Now, one of the things I do in Alaska is sometimes I will enter a limited appearance just to represent the respondent on the forced drugging part, because they want to do them all together. And I say no, and it's actually a two-stage process. They have to be committed first before they can get a forced drugging order. So anyway, he'd been committed, and we lost in the trial court, but we presented these affidavits, and then they were cross-examined, and the Alaska Supreme Court granted a stay. So we've got a motion for stay, we've got a copy of the Alaska Supreme Court's order granting the stay and their reasoning. Okay, and there's a form certificate of service, because some people are trying to do this themselves. And there's a Microsoft. Is there a Microsoft Word version? I think there is of this on the web too, so people can adapt it. All right, so I'm getting shorter on time. Basically, to summarize, the goals of strategic litigation are to force the system to honor people's rights. And one of the ways I look at it is that it's good just to make it harder on them to get these orders. It is so easy for them to get these orders that it's really the path of least resistance. And if you can make it harder, they will, try and do something easier. And one of my favorite stories is after the Myers case. I mean, it went up after the 30-day hearing, but then there was a 90-day and 180-day proceeding. And it was a 4-month, all-out legal battle, the likes of which the hospital had never seen before, and they didn't like it. And shortly after that, I got a call from someone, and they had to file a petition the next morning on him if they wanted to hold him. And I talked to him, and I didn't think he met commitment criteria, so I let the hospital know that if they filed a petition, I would represent him. And they tried real hard to find something else. And I actually never met him. Because literally, as I was driving up to the hospital to meet him the night, that night, he was driving away. I saw the car drive away. And they had found something else. Okay, and another purpose is to compel these other alternatives. I've got till 9:45, right?
You're good.
Okay. Compel other choices, as I talked about before, and there's some public education potential. Okay, so I'm going to talk a little bit about what's happened in Alaska. I did not take this picture, but someone sent it to me. It's Mount McKinley. So I wrote this law review article, Involuntary Commitment, Enforced Psychiatric Drugging in the Trial Courts, Rights Violations as a Matter of Course. You can download it from the homepage of the PsychRights.org website. It's in the Alaska Law Review, and they send the Alaska Law Review to every lawyer and judge in the state. And I think maybe 2 people have read it. So it hasn't been cited much. But actually, I've seen it cited in some briefs recently. And in it, I go through a lot of the same stuff, and I identify about half of the places, I write about half of the places that I've identified where they actually operate illegally. So the results. In Myers, 2006, in Alaska, the statute says if the court finds someone incompetent, the hospital can do whatever it wants. Well, first off, the transcript of the hearing is on the website, and I defy anybody to say that she was not competent to decline. But anyway, she was found incompetent, and we said, well, hey, you can't do that under the Constitution. You've got to at least show it's in the person's best interest, and there's no less intrusive alternative. And really, I didn't make that up. The guy who, that won that is in the room, I think, Bill Brooks, Rivers versus Katz in New York. And so the Alaska Supreme Court held on Alaska constitutional grounds that was true, except they said that there can't be any less intrusive alternative available. So what does available mean? In Weatherhorn, the statute, it was the question of whether someone could be locked up for being gravely disabled, and there are 2 prongs of the statute. One, the A prong says serious illness, injury, or death is highly likely if you don't lock someone up. Okay, well, I buy that as a constitutional matter. But the B prong was that if you don't lock the person up, their previous ability to function independently in the community will deteriorate. Okay, I go, wait a minute, you can't do that. And so the Supreme Court agreed, again on Alaska constitutional grounds, because they're smart enough to know that if they decided on the U.S. constitutional grounds, the U.S. Supreme Court might take it. Anyway, so, but they followed the U.S. Supreme Court and said that that can only be constitutional if that means that they're unable to survive safely in freedom. Okay. And then Wayne B. was a procedural case, which Professor Perlin says he thinks is really important. But what happens in Anchorage is the Superior Court, which is the court of general jurisdiction, has jurisdiction over these cases. And the judges are randomly assigned, and then they're automatically referred to a probate master who only has authority to make recommendations. And the rule says that they've got to give a transcript to the Superior Court judge to decide, as part of what they get to decide whether or not to approve the recommendation, follow the recommendation. And since statehood in 1959, they had never done it. And in fact, the Public Defender Agency in Alaska had never taken any appeal of any involuntary commitment or forced drugging case since statehood in 1959. So anyway, we appealed and said, hey, there was no transcript. The judge has to do it. And the Supreme Court agreed, except that they said Well, you have to have the transcript, or the judge can listen to the recording of the hearing, which I think is asinine, because now you've got, and they still don't do the transcripts, and so now you've got the probate master spending all the time at the hearing, and then you've got the Superior Court judge listening to the same hearing. What's the time saving? So what actually happens is that they probably pretend to listen to the recording. And I had one of my Bigley cases, the judge actually said, oh, I hadn't listened to the recording. Basically when, as he was throwing me out of the case. Anyway, but there's one Bigley case that went, another Bigley case that went to the Alaska Supreme Court. And one of the issues is, what does available mean? And we said, once you have taken this person and locked them up and now want to drug them against their will, that causes the right to have this less intrusive alternative that the state now has to pay for it. And the Supreme Court didn't go with that, but they said they either, if it's feasible, they have to either provide it or let the person go. And that's an example of someone, of a situation where the appellate courts really didn't think it through, because he's only locked up because he's been found to be too dangerous to be let out. But of course that's a pretty bogus determination in most instances anyway. Mr. Bigley, I think, got up to 100 admissions before he passed away last year, about a year ago. The other thing they said is the failure to provide evidence sufficiently in advance was a due process violation. I could tell you more about it, but I'm really running out of time. And the petition must include detailed allegations on best interest. So in Myers, they said, best interest means you've got a, prognosis with or without, alternative side effects, those sorts of things. And at oral argument, I said, they really ought to, they should have to say all that stuff so we have notice of what it is that, my client's being charged with. And they agreed. So I thought that was pretty important. Of course, they basically ignore that. The case we have in the Supreme Court right now is, as in most states, the police can just bring anybody in for psychiatric evaluation, right? I mean, I think that's true in most states, if not all. And our point is, once a person, and then the statute says, well, if the hospital thinks they should be, held longer, they get an ex parte, they go file for an ex parte order. And I'm going, hey, wait a minute. Where's the emergency? What's the exigency that justifies no notice, an opportunity to be heard? So it's a very simple argument. And my brief, I only have 2 pages on that argument. The rest of it is whether or not the Supreme Court should actually consider it, because they have this idea that these cases are moot. An oral argument is the middle of next month. So that's the strategic litigation that we've done in Alaska. In public education, we've brought up Mr. Whitaker, actually 4 times, Professor Perlin, who's been a frequent speaker here, and Robert Whitaker presented a seminar to lawyers and judges and actually clinicians and consumer survivors, and so that was part of it. In winter of 2011, 2012, we did we showed Daniel Mackler. We had a Daniel Mackler film series, and one of the things is that I try and accept all possible speaking invitations, and I think everybody in this room should make that as a policy too, because that's how we get the message out, and it's important for people to see, especially psych survivors, that we're not all crazed lunatics that are going to kill them in their beds. Okay, so in terms of media coverage, the Myers case got some. There's a feature front page story on me. The Zyprexa paper's got some local coverage. The Medicaid fraud case got some local coverage. And then a year ago, the local NBC affiliate had a series, Mind Over Meds, in which I was featured a couple times. So, what has all this done? I think that what happened with Soteria, I think, is illustrative. In 2002, when we brought Robert Whitaker up to speak to the Alaska Mental Health Board, basically the reaction was by the executive director, oh, we're not endorsing what we're saying, it's just educational. The head of the Mental Health Trust Authority, which is a really big player there, went to the seminar in 2003, and he said, well, gee, what you're saying implies that we need non-drug alternatives. You know, it's like, duh. But anyway, that was important. We, applied for funding from the trust, and one of the really unique features of the trust is that it gets to spend its money without the legislature having anything to say about it. And so they said, well, it's interesting, but needs more development. In that story in 2005, that same executive director of the trust said, the question isn't if we're going to, have these kind of alternatives, but when. In 2006, the trust authority said, we'll fund it, but the state's got to put in a share, which is its basic mode, is they'll put in some money and then they say, you state, put in some of your money. But then in 2007, when the state wouldn't put in any money, they said, okay, we're just going to fund it all on our own. It opened in 2009, and in what I think was a kind of minor miracle, the people at Soteria got it in the state budget in 2010. And I actually got off the board many years ago, probably around 2005 or 2006, because like Daniel said, I was suing them, and I thought it was kind of awkward to be suing them and then asking for money at the same time. So Soteria opened in 2009. Now Choices Inc., Soteria is a diversion program for people that would otherwise be basically committed in the hospital. Choices is a community program. It stands for consumers having ownership and creating effective services. I hate the word consumer, but I love the acronym, even though maybe because I made it up. Anyway, so that's kind of that. So the current Alaska status is, I would say that it's changed from the attitude that psych drugs for everyone forever, of course, to pretty widespread support for non-drug alternatives, non-drug choices. And that's kind of in theory, at least. I think in practice we're not really there, though. I think Choices in Soteria, as Daniel mentioned, have really gotten accepted as providing valuable service. It's receiving Soteria is receiving some referrals from the hospital. The least restrictive, intrusive alternatives is enshrined in recent Alaska Supreme Court decisions. I wouldn't say that that's being honored very much at all. We've really shifted to working on children, so we haven't really pressed them that much. I think I'm right at my time. Do you want me to quit? Or?
Take 5 more minutes.
Okay. I want to talk just a little bit about drugging children and youth in state custody. There's this really awful case, DeShaney versus Winnebago County, where the state returned a child to the custody of a father who was known to be abusive, and the child was harmed. The Supreme Court said, well, once the state has turned the child loose, they have no responsibility or liability. So that's an awful case. But they also said, when the state, by the affirmative exercise of its power, so restrains an individual's liberty that it renders him unable to care for himself and at the same time fails to provide for his basic human needs, in other words, food, clothing, shelter, medical care, and reasonable safety, it transgresses the substantive limits on state actions set by the 8th Amendment and the Due Process Clause. And I think that means they can't drug people, they can't drug children in state custody, because these drugs can be shown to harm them. And anyway, I don't have time to go into the case where we got thrown out of court. We're looking at on a state case. if we had the resources, we'd probably file a federal 1983 case. And then in the getting Al Capone for tax evasion category, it turns out that most of the Medicaid psychiatric drugging of children and youth is Medicaid, and that it's not allowed under Medicaid. That the government ignores that. But basically, off-label prescriptions are only allowed if there's support in these drug references, one of 3 drug references called compendia. And we have a chart of what are medically accepted indications and what there can be arguments over. It's a little bit dated. It's not on that chart. If it's not white on that chart, we say it's not a medically accepted indication and it's not covered. If it's orange, there can be an argument over. But most of it's not even on the chart. If it's not on that chart, it's a false claim. And the 7th Circuit, just last month, basically confirmed that approach. And they said that doctors knowingly cause false claims by writing prescriptions not for medically accepted indication, which means approved by the FDA or supported by one of these compendia. And so I think this is a very big potential wedge into this. And the idea is that each prescription carries a minimum penalty of $5,500. And so any psychiatrist or other prescriber probably would have done at least 1,000 of these in the 6-year statute of limitations. That's $5.5 million. And the idea is to scare the shit out of the other docs into stopping it. Okay, and so I'm going to talk about this tonight at 7 o'clock, go through it at some length, and we really want to get more of these cases going. In contrast, I just should point out that the 9th Circuit essentially ruled, if the government doesn't care, why should we? But that's not the law in the 7th Circuit, and that was a non-precedential ruling. So, I'm done.
Good here.
You can close it or whatever you want.
Oh, thank you. Thank you very much. Am I on? I'm on. I want to add one thing, and that is that I am not alone in considering Jim a genuine hero. And we are all really happy that we can spend some time with him. Yes.